such a big landmark decision in the Indian insolvency era. Primarily because this is a case where the account was a non-performing account, and the promoters originally came forward to pay a very insignificant portion of the total dues. And subsequently, when the insolvency proceedings were taken, the promoters did all within their might to try and either stall or delay the inevitable. And finally, the judiciary came on top of it and said the case has to move through the way mentioned in the IBC code. And the case has taken a successful resolution, consequent to which close to about 45,000 crores of amounts which were thus far considered not recoverable have been recovered. So let's quickly move on. I would like to thank Sundar and Meenakshi for their contribution in getting the presentation in place for us today. So these are some of the terms which have been used, friends. I think we shall see most of it as we start going in. COC, Committee of Creditors, AMI is ArcelorMittal, IBBI or board refers to the Insolvency Board and not the CBDT, which we usually look at. CIRP is Insolvency Corporate Insolvency Resolution Process. NCLT or Adjudicating Authority, NCLAT is Appellate Tribunal. OC is Operational Creditors, Reserve Bank of India. Of course, regulations we talk about IB regulations. RP is Resolution Professional. Yes, quickly move on. This would be the agenda for the day. What are the key dates? This is more like a timeline what we will be doing in terms of how the entire case panned out over its course of existence, and what was the resolution plan which got approved, the judgment of NCLAT, subsequent amendments in Insolvency Bankruptcy Code, Supreme Court decision 15th of November, and what are the key inferences. A fairly comprehensive outlook on all these aspects shall be dealt with. So the case started effectively from 13th of June when the RBI identified 12 large stressed accounts in the steel infrastructure and the infrastructure sector for immediate resolution, of which one of the cases was Essar Steel. 27th of June, Section 7 application was filed under the Corporate Insolvency Resolution Plan by SBI and Stanchart. Both were lenders for recovery of their dues. In about a week's time, the company filed a writ petition challenging the move to recover under IBC. Thankfully, Gujarat High Court dismissed the plea, and hence the proceedings under IBC started. 2nd of August, the NCLT admitted the application filed by the lenders to initiate the proceedings. 6th of October, the IRP sought resolution plans from potential investors, inviting expressions of interest. Essar's parent company also came on board as one of the potential investors. Now the challenge here is a case for, imagine friends, subsidiary is gone into resolution and the parent company has come on board saying we will be one of the potential suitors. So let's say if the subsidiary's dues are 10,000 crores. Post haircut, let us say the highest bidder is 2,000 crores. The parent would want to say that I would also pay this 2,000 or 2,100 crores and acquire. So instead of putting funds into the company to bail out its subsidiary, the company is saying let the banks bear the brunt and we shall focus on reacquiring the company, our own company, net of all these losses. Then Section 29A was introduced, which said that the bidders who are deemed as willful defaulters or promoters with default track record and their related parties would not be eligible to bid. Therefore, Essar Steel promoters were hence barred from bidding. And what happened in the process? The promoters were required to repay the dues to take part in the bidding process. Numerical and ArcelorMittal had also submitted their bids, again pursuant to the introduction of Section 29A, which said defaulting promoters will not have a chance to chance to participate in an IBC proceeding. Then March 18, interesting things happened. The resolution professional states that the bidder is ineligible under 29A of IBC since because of New Metal's connection with SR Group Ruyas and ArcelorMittal's stake in an NPA account. So ArcelorMittal had a stake in a company which was in an NPA, which was deemed as an NPA. Now came the case where both, and since New Metal had a connection with the Ruyas, who were the original promoters of Essar Steel, New Metal was also not eligible to apply for it. Then fresh bids were initiated on 2nd of April. Again, ArcelorMittal applied, New Metal and Vedanta submitted their bids. Then 19th April, NCLT orders the Committee of Creditors to reconsider the bids of resolution applicants and to give sufficient time to cure disabilities in resolution plan in accordance with the provisions of IBC. Again, what happens? New Metal, Arcelor, they moved to NCLAT, where they said they were not disqualified. NCLAT holds New Metal's bid valid after they severed ties with the Ruyars, and ArcelorMittal was asked to clear the dues of Uttam Galva, a company in which they held stake, and KSS Petron. The dues were about 7,000 crores. Subsequently, ArcelorMittal had settled these dues and then became eligible to bid. On 4th of October, the Honourable Supreme Court gave 2 weeks' time to both Arcelor and New Metal to pay off the NPA dues, failing which the debtor would go into liquidation. SC allows ArcelorMittal and New Metal to bid for Essar Steel and asks the Committee of Creditors to decide the issue. Arcelor makes a payment. However, New Metal did not make any such payment. So therefore, New Metal was by default disqualified from being an eligible suitor. And ArcelorMittal resubmitted its resolution plan, which was then evaluated by the COC on the same date. And finally, on 25th of October, the final negotiated resolution plan of ArcelorMittal was approved by Committee of Creditors by a 92.24% majority. This is a landmark decision, friends. If you look at the ups and downs the entire case has taken. Meanwhile, the operational creditors filed petition challenging Mittal's plant. Stanchart files a separate petition against ArcelorMittal plants. Stanchart was deemed as an operational creditor and not as a financial creditor. That's where the challenge came. NCLAT asked NCLT, the Ahmedabad bench, to pass a final order on 8th March. This is independent of the eligibility. The issue came whether operational creditors should be deemed at par with financial creditors. The NCLAT gave its final judgment giving equal status to both financial and operational creditors. Agreed financial creditors then filed before the Honourable SC against NCLAT's order. And finally, on 15th November, the Supreme Court gave its judgment, which set aside NCLAT's order giving financial creditors upper hand over operational creditors, because that's how the scope of or the priority for resolution also stands in your Insolvency Bankruptcy Code. Now before we get to analyze these, let's try and understand the key aspects, how the corporate insolvency process actually works. So first, you file an application before NCLT. Then there is a preliminary adjudication process where the application is either accepted or rejected. Then there is a moratorium and a public announcement. Then a resolution professional is appointed. Committee of Creditors is formed. Then preparation of the resolution plan, which needs to be approved. And then if there is a plan which is not submitted, there are legal consequences which will follow. Technically, the whole episode has to be completed within 180 days. It can be extended by another 90 days, making it 270 days. Now, 29A was a consequence of this particular case, where a defaulting promoter will not be given the right to reapply, or participate in a resolution bid. That's why 29A was introduced in the IBC. And I'm not getting into the definition of the term 29A because we can talk about it for a couple of days on this. Then the resolution plan has to be submitted by the resolution professional, and it shall provide primarily for payment of all the insolvency costs, payment of debts of operational and then financial creditors, operational creditors, and then the plan has to be approved. The resolution plan shall be presented by the professional to the committee of creditors for approval. The COT may approve a resolution plan by vote of not less than 2/3, which is 66%. The resolution plan, the resolution applicant may attend the meeting of the committee of creditors, and the resolution professional shall submit the resolution plan as approved by the COC to the adjudicating authority. Now, this is where the issue comes, friends. Section 53. This is the second aspect which was decided by Supreme Court, the fight between Stand Chart and other creditors. So now, Section 53 of the IBC Code categorically talks about how or in what priority the resolution plans will be considered. The resolution proceeds will be set aside. First will be the costs and expense of insolvency. Then workmen's dues for the period of 24 months and dues of secure creditors preceding the liquidation. Wages and any unpaid dues owed to employees other than workmen for the period of 12 months preceding the liquidation commencement date. Then comes unsecured financial creditors. Then comes statutory dues for the period of 2 years preceding the commencement date. And then comes other debts and dues. Now, Supreme Court decision, Section 29A of IBC, fantastic decision because this is what forced both Uttam Galva and KSS Petron's dues to be settled. So NCLT admitted applications filed by financial creditors of Essar Steel, and subsequently a resolution proposal was initiated. ArcelorMittal, New Metal, and Vedanta had submitted their resolution plans. The resolution professional found both the resolution plans of these two, New Metal and Mittal, to be ineligible, consequently 29A. ArcelorMittal BB, which was a connected person of the bidder, was the promoter of Uttam Galva, and the account of Uttam Galva was an NPA for more than a year. Further, the connected person was also a promoter of KSS Petron, which was also an NPA. And New Metal shareholding at the time of submission of resolution plan was held by Aurora Enterprises, which was held completely by Revant through some trusts and companies. And hence, New Metal was also a connected person. Now, consequent to this, what were the issues which the SC dealt with? Because this principle is very critical. Whether the stage of ineligibility of the resolution applicant under 29A of the IBC attaches at the date of commencement or at the time when the resolution plan is submitted. So this is very clearly discussed, and the solution was it needs to be considered at the time of resolution plan being submitted and not at the time of application. Whether the resolution applicant can challenge the rejection of resolution plan. Again, very clear, the resolution applicant cannot challenge the rejection of resolution plan. However, it was held that the resolution professional does not have the power to reject the resolution plan and directed him to present all the plans before the COC for their consideration. So if there are 10 plans which have come, the RP does not have the discretion to reject it, but he only needs to submit all these plans to the committee of creditors. Whether NCLAT was right in holding that Mittal was ineligible to submit resolution plan and New Metal was eligible to submit. Mittal was ineligible and New Metal was eligible to submit in accordance with 29A. Both the resolution applicants had not paid their respective NPAs prior to submission, and they both were hit by 29A and therefore were ineligible to submit their resolution plan. So there is no need for being partisan in this case. So the final conclusion which we can draw from this, 29A is introduced in order to prevent promoters related to management of corporate debtors from bidding from their own assets at steep discounts. Further, promoters having NPAs existing in any of the entities shall not be eligible for resolution plan unless those dues are cleared. RP is not required to take any decision, but he is only expected to ensure that the resolution plan submitted are complete in all respects. And approval of ArcelorMittal's plan. On 18th of October 2018, ArcelorMittal cleared off their NPAs as ordered by the Supreme Court. Numerical did not settle their dues. So ArcelorMittal resubmitted its resolution plan and it was declared as the highest and the most successful bidder vis-a-vis Vedanta, and it was passed by an approval of almost 92.2%. The resolution plan as approved. I'm not getting into the facts of the numerical facts of the case, as that would be more academic in nature. NCLT approval. Mittal's plan was submitted by resolution professional to NCLT. Operational creditors and Stanchart filed a petition against Mittal's resolution plan in NCLT. NCLT in its order dated 8th March approved the resolution plan with directions to COC of Committee of Creditors of Essar Steel to modify the plan to benefit Stanchart. And the COC of Essar Steel had appealed before NCLAT against the direction of NCLT, because the case was Stanchart wanted to have a pro rata standing along with financial creditors, and interlocutory orders were given by NCLAT, and Supreme Court stayed the order of NCLT, and the Supreme Court had asked NCLAT to speed up the disposal because this case was being monitored globally. And finally, what the issue of Stanchart had an outstanding of 3,480 crores and was eligible for only 59 crores, which is effectively 1.7% of the total claim received from the transaction, which is why there was such a big noise by Stanchart in this regard. Let's quickly look at the issues here. Mr. Prashant Ruiha, who was a promoter, had challenged the order on the ground that Mittal is ineligible in terms of 29A. But again, this was discussed by NCLAT. The eligibility of ArcelorMittal as a resolution applicant cannot be re-agitated again and again. So they said that this has to be dropped because this was more a case to delay the inevitable. Committee of Creditors can delegate its powers to a subcommittee or core committee for negotiation. There is no provision under IBC which permits constitution of a core committee or a subcommittee, hence that is not possible. Whether COC is empowered to decide the manner in which the distribution is to be made between one or other creditors. COC has no role to play in the manner of distribution of amounts. They're only required to notice the viability, feasibility of the resolution plan. Similarly, treatment of profits arising out of business of corporate debtor during the insolvency resolution plan. The amount of profit, if any, generated cannot be given to the successful resolution applicant as he is yet not invested. This should be distributed amongst all creditors, financial and operational creditors, on a pro rata basis of their claims. And whether resolution applicant can take advantage of 53 for the purpose of determination of the manner of distribution of the proposed upfront amount is to be made in favor of one or the other stakeholder. The resolution plan must provide for the payment of debts of operational creditors. Section 53 cannot be made applicable for distribution of the amount amongst the stakeholders. So how the final, these are more operational aspects of the decision, friends, so I wouldn't want to get into this. The NCLAT decision, the financial creditors should be treated at par with operational creditors, thereby giving an equal share of 60.7% of the total admitted claim. Stanchart, one of the financial creditors but has no charge on project assets, gets 60.7% as against previous 1.7%. And operational creditors get 60.7% as against the previous 20.5%. So this was a decision of NCLAT where they kept secured financial creditors without any charge on project assets to be at pro rata with secured creditors with financial charge. and also operational creditors were also kept at par with secured financial creditors. Post the NCLAT decision, the some of the amendments which were introduced in the IBC, the CARP shall mandatorily be completed within a period of 330 days, the resolution process from the commencement date, and where the CIR is pending, the resolution process is pending and has not been completed, such process shall be completed within 90 days from the date of commencement of this particular act. So the regulators now came ahead to put a finite time frame to closure of a resolution. Similarly, section 32 was introduced, where it said that the resolution professional shall examine the plan received by him to confirm that each plan provides for payment of debt, and which shall not be less than the amount to be paid to such creditors in the event of liquidation, or the amount would have been payable to creditors if the amount distributed under the resolution plan had been distributed in accordance with the order of priority under 53(1), whichever is higher, and it provides for payment to dissenting creditors who do not vote in favor of the resolution plan in a manner which ensured that the amount payable shall not be less than the amount to be paid to such creditors in the event of liquidation. So effectively, the role of a resolution professional is only to ensure the compliance of the submitted resolution plan, and he does not have a discretion to choose whether a particular plan will sail through or is appropriate or otherwise. The Supreme Court decision in this regard, the role of COC, the Committee of Creditors, it's the commercial wisdom of the Committee of Creditors to decide as to whether or not to rehabilitate the corporate debtor by accepting a particular resolution plan. The insolvency resolution is ultimately in the hands of majority vote of the COC, which is 2/3 vote. What is left to the majority decision of the COT is the feasibility and viability, and it also takes into account all aspects of the plan. It's a commercial wisdom again of the majority of the creditors to determine through negotiation with the prospective resolution applicant on how the resolution process shall take place. Yes, this is a very important rationale propounded by Supreme Court. Secured and unsecured creditors. If an equality for all approach recognizing the rights of different classes of creditors is adopted, secured financial creditors will in many cases be incentivized to vote for liquidation rather than resolution, as they would have better rights if the debtor is liquidated, and this would fundamentally defeat the purpose of IBC, because the intent of IBC is not to shut down companies but is to give them life. Second, the amended section 38 regulation 38 does not lead to conclusion that financial and operational creditors or secured and unsecured creditors must be paid the same amounts percentage wise under the resolution plan. Fair and equitable dealing of the operational creditors' rights under section 38 involve the resolution plan stating how it has dealt with the interests of operation creditors, which is not the same thing as saying that they must be paid the same amount of debts proportionately. Similarly, it is a commercial wisdom of the requisite majority of COC, which is to negotiate and accept a resolution plan, which may involve differential payment to different classes of assets. But that's a given, friends, because you cannot have a case where someone with a definite right and someone with a floating charge be treated one and the same. And profits which have been earned during the course of the resolution plan should not be distributed to the successful resolution participant, and the distribution shall be made during the resolution process and will not go towards payments of debts of any particular creditor. Amendment of section 12, the term mandatorily is struck down as being manifestly arbitrary under Article 14 of the Constitution. The effect of this is that the ordinarily time taken in relation to the resolution process should be completed within 330 days from the insolvency commencement date, including whatever extension happens consequent to legal challenges. Next, the resolution plan, the Mittal's resolution plan, the appeals filed by COC of Essar Steel and other civil appeals are allowed, setting aside NCLAT's order. The resolution plan of the corporate debtor in this case will take place in accordance with the plan submitted by ArcelorMittal. Primary inferences. It's the wisdom of the requisite majority of creditors, committee of creditors that must prevail. And while executing the commercial wisdom, it is the duty to take care of all the interests of all the creditors. That doesn't mean that operational and financial creditors will be kept at the same level. The limited judicial review available to the adjudicating authority has to be within the four corners of Section 32 of the IBC. In respect of NCLAT, it has to be within the parameters of Section 32 read with 61.3. Such review can in no circumstance trespass upon a business decision of majority of the committee of creditors. Again, going back, friends, the second aspect of the judgment is to very clearly state that any creditor having a specific charge over an asset will have priority over a creditor having a floating charge of assets, and therefore taking care of the commercial wisdom of taking care of every creditor's interests does not mean that the proceeds available shall be distributed proratedly. Fantastic case in the insolvency journey of India, and hope you've had a good time trying to understand this. Any doubts, will be more than happy. Else catch up again on another conversation pretty soon. Thank you.